Today I will be speaking on environmental constitutionalism and sustainable development goals. As you may be knowing that this is an aspect which is directly related to each one of us in one way or the other. So I have divided this topic in four parts. First, I will be discussing environmental constitutionalism and its concept. In the second part, I will deal with the Sustainable Development Goals and how these Sustainable Development Goals are linked with environmental constitutionalism. I'll be giving some examples also. In the third part of my lecture, I will discuss the Indian perspective on the environmental constitutionalism and sustainable development goals. And the final part is Indian judicial perspective on the environmental constitutionalism. So, first, environmental constitutionalism is a concept which refers to the recognition and protection of environmental rights and responsibilities in a country's constitution. Basically, it involves the establishment of legal frameworks that promote the sustainable management and conservation of natural rights. That is, we can say that if we want to have the environmental constitutionalism, then it requires that the rights of the common man, that is the citizen, for clean and healthy environment must be protected. The main goal of the environmental constitutionalism is to ensure that the protection and preservation of the environment are embedded in the legal system and are given the same importance as the other constitutional rights, because we know that constitution confers many of the rights, and those rights are given the similar importance. There is no hierarchy of the rights, which right is going to be the higher right, which right is going to be the right which is having a less value. All are of equal importance. So this simply means that the government has a responsibility to protect the environment and to ensure that natural resources are used in a sustainable way. So environmental constitutionalism basically recognizes that environment is a fundamental human right. So when I'm talking that this is a fundamental human right, so this is a right which is associated with each one of us. And that is the responsibility of the governments to protect and preserve the natural resources that support life. And basically, it requires that the environmental protection be given priority in policy making and in decision making processes. So it is the work of the government that they should make the policies through which the environment can be protected, and at the same time, whatever decision making processes are there, that also inquires and that also says that the environmental protection must be given the priority and the preference. So the principle of environmental constitutionalism has we can say adopted by several countries around the world, and it is seen as a powerful tool for ensuring the sustainable development. The legal frameworks which have been established through environmental constitutionalism vary from country to country, because we know that environmental issue is an issue which knows no geographical boundaries. And that's why there are so many Earth summits, there are so many treaties, instruments at the international level in which many of the countries are the party to that, and that's why they have also incorporated in their legal frameworks many of the provisions which establish environmental constitutionalism. But each country is not having the same provision. They vary from country to country, and in some cases, you will find that they may include the provisions for the protection of natural resources, such as the forests, the water bodies, and the wildlife, while in some of the cases they may include the provisions for regulating of the pollution and for making the laws for polluting industries and the enforcement of the environmental standards. So, environmental constitutionalism has been used in several provisions in the countries, and they have incorporated these provisions either in their constitution or in their other acts and statutes. It depends that in which provision they have incorporated. As I told you, it may be relating to the natural resources protection, it may be related to the regulatory bodies and polluting industries, which has to enforce the environmental protection. At the same time, the environmental constitutionalism has also been used in several cases also. For example, if I will tell you the case of South Africa, then the case of Fuel Retailers Association of South Africa, that is important, in which the constitutional court there recognized the right of the citizens for a clean and healthy environment. And at the same time, there is one more case, that is the case of Oginda versus Chevron, where you find that the Constitutional Court ordered to pay a very large amount for environmental damages which has been caused by the oil drilling. So basically, environmental constitutionalism is a powerful tool for ensuring sustainable development and protecting the environment. So, by adopting environmental constitutionalism, countries can protect the environment and ensure a clean and healthy environment for the present and future generations. So, when I'm saying it is for the present and the future generations, it simply means that the sustainable development goals are directly related to the environment or environmental constitutionalism. The second part of this lecture is related to the sustainable development goals. So, as you may be aware that the sustainable development goals are a set of 17 global goals which have been adopted by the United Nations General Assembly in 2015 as a part of the Agenda 2030 for Sustainable Development. That is, these 17 goals are to be achieved by 2030, and from now it is 7 years that we have to achieve these goals, which are related to many of the aspects, like it is aiming towards no poverty, to protect the planet, to ensure the prosperity for all by addressing the social challenges, economic challenges, and environmental challenges. So these goals are basically the global goals, and the Sustainable Development Goals recognize the importance of environmental protection and sustainable development, and at the same time they call for the governments, the businesses, and the individuals to take action to achieve these goals. So it is not confined only to the government bodies that they have to protect the environmental pollution and they have to protect the environment to make that sustainable. But at the same time, the business companies, the industries, they are also to take the proper goals, how to achieve these goals. They have to take the action how to achieve these goals, and even the individual has to take some action to achieve these goals. So the 17 goals which are there, they are said to be integrated, and they recognize that action in one area will affect the outcomes in the other areas also, and that the development must balance the social sustainability, the economic sustainability, as well as, of course, the environmental sustainability. And these goals are directly related with the environmental constitutionalism in one way or the other. For example, as I told you that there are 17 goals, so many of these goals are directly related to the environmental constitutionalism, but I'll be giving you the examples of 2, 3 goals whereby I will try to make a link of the sustainable development goals with that of the environmental constitutionalism. However, there are no poverty as a goal, zero hunger, good health and well being, clean water and sanitation, affordable and clean energy, responsible consumption and production, climate action, life below the water, life and land. These are few goals which are directly you find that linked with the environmental constitutionalism. So I'll be trying to make a link between these two. The very first goal is the no poverty. That means that eradicating poverty is not a task of charity, but it is an act of justice. And it is also the key to unlock an enormous human potential. Because if the person will live in poverty, below poverty line, then many of the things will not be achieved by, and in that way the potential of that particular human will not be contributing towards the national development. And that is how it is said that it is not a task of charity, but it is an act of justice. If you see many of these surveys which have been conducted at the national and international level, we find that nearly half of the world's population that lives in the poverty, and lack of food and clean water that is killing the thousands of them every single day for the years. And there is a strong link between the poverty and environmental constitutionalism, because poverty and environmental degradation are closely interlinked and mutually reinforcing. People living in poverty, they often rely heavily on the natural resources for their livelihood, and as a result, they are more vulnerable to environmental degradation and the depletion of natural resources. So, this in turn can lead to further impoverishment and marginalization of the vulnerable communities. Environmental constitutionalism can also help to address this problem by providing legal framework, and that can recognize and protect the environmental rights and responsibilities, and can also ensure that the environment is managed sustainably for the benefit of all. So such legal framework can ensure that the rights of the marginalized and the vulnerable communities to a clean and healthy environment are protected, and that natural resources are managed in a sustainable way that benefits all the members of the society. Further, environmental constitutionalism can also help to promote the sustainable development and poverty reduction by ensuring that economic development is pursued in such a manner that that is consistent with the environmental protection and sustainable resource use. For example, if I say that environmental impact assessments can be used to ensure that development projects do not cause harm to the environment, and that they benefit local communities, particularly those who are living in poverty. Furthermore, environmental constitutionalism can provide opportunities for the participation and also for empowerment of the marginalized communities in environmental decision making processes. So, this can help and ensure that the voices of those most affected by the environmental degradation are heard, and that their perspectives are taken into account in the environmental decision making. So, poverty and environmental degradation are very, very closely linked, and environmental constitutionalism can play a crucial role in addressing this problem. So, by recognizing and protecting environmental rights and responsibilities, promoting sustainable development, and also ensuring participation and empowerment of the marginalized communities, the environmental constitutionalism can help to reduce poverty and promote a sustainable and just future for all. Another example, if I can give, of the good health and well being. because good health and well-being is another goal that is closely linked with the environmental constitutionalism. A clean and healthy environment is essential for maintaining good health and well-being, and environmental constitutionalism can help ensure that the environment is managed sustainably for the benefit of all. So, this environmental constitutionalism recognizes that access to clean and healthy environment is a fundamental human right, and that government has a duty to protect this right. And this includes the protection of the quality of air, quality of water, and the quality of soil, as well as protecting the biodiversity and the natural ecosystems also. So, when the environment is degraded, it can have negative impacts on the human health and well-being. For example, exposure to air pollution that can lead to the respiratory diseases, while contaminated water can cause waterborne illnesses. At the same time, environmental degradation can affect the food security and nutrition also, which are all very essential components of the good health. So, environmental constitutionalism can help and address these issues by providing legal frameworks that recognize and protect the environmental rights and responsibilities, which are for the benefit of all. And such legal frameworks can also promote the sustainable development and poverty reduction, which are very, very essential for achieving good health and well being. So, environmental constitutionalism is crucial for achieving good health and well being. And by recognizing and protecting the environmental rights, we see that it is also ensuring the participation and empowerment of the marginalized communities. And environmental constitutionalism can also help that everyone has access to a clean and healthy environment, which is essential for good health and well-being. And then environmental constitutionalism is also closely linked with the goal of affordable and clean energy. This is one of the goal under the Sustainable Development Goals for that affordable and clean energy. And access to affordable and clean energy is essential for sustainable development and for reducing poverty also. Environmental constitutionalism can help ensure that energy is produced and consumed in a manner that is sustainable and that protects the environment. So, one way in which environmental constitutionalism can promote affordable and clean energy is by encouraging the development of renewable energy sources, such as solar source and wind through wind and through hydropower. So, environmental constitutionalism can provide legal frameworks also that recognizes the importance of renewable energy and that promote its development through incentives and by regulations also. And in addition, you see this environmental constitutionalism can promote energy efficiencies and conservation, which can help reduce the demand for energy and promote the use of clean energy sources. Legal frameworks can also be put in place to promote the use of energy efficient technologies and practices, and that can also encourage the conservation of the natural resources. Uh, Furthermore, the environmental constitutionalism can help to ensure that the energy production and the consumptions are managed in a sustainable way that protects the environment. So we see that the environmental impact assessments that can also be used to assess the environmental impacts of the energy projects. And the regulations can be put in place, like as in other goals I have just discussed with you, and that would also be very, very beneficiary because that will ensure that the energy production and consumption are sustainable and they do not harm the environment. So, therefore, environmental constitutionalism is very crucial for achieving the goal of affordable clean energy. Further, access to clean water and sanitation is essential for human health and well being. And environmental constitutionalism can help to ensure that water resources are managed sustainably and that the sanitation systems are effective and safe, because environmental constitutionalism recognizes that access to clean water is a fundamental human right, and the government has a duty to protect this right. So this includes the protecting of the quality of water sources, regulating water use and allocation, and ensuring that sanitation systems are effective and safe. In addition, you see that environmental constitution can also promote the sustainable management of water resources through the protection of the watersheds and wetlands, and the regulation of the water use in agriculture and industry can also be ensured. And this all will help to ensure that water resources are available for the current and the future generations, and that the water quality is maintained. So, environmental constitutionalism can help to ensure that sanitation systems are effective and safe. And this includes the regulation for wastewater treatment, the disposal, and the promotion of safe sanitation practices, such as hand washing and proper waste disposal. So, environmental constitutionalism can promote the development of sanitation systems and that are appropriate for different contexts, such as rural areas or for urban slums. So, environmental constitutionalism is very, very essential for achieving the goal of clean water and sanitation, which are essential for the human health and well-being. So, there is a direct link with that of these sustainable development goals with that of the environmental constitutionalism. Now, in the next part, the Indian perspective of environmental constitutionalism. So far as India is concerned, we know that the environmental constitutionalism refers to the recognition and protection of environmental rights and responsibilities in the Indian Constitution. And India is one of the few countries in the world with a constitutional provision for environmental protection. Though we know that in the original constitution we were not having the direct provision for the environmental protection, but after 42nd amendment we have introduced many of the provisions which are directly related to protect the environment, whether it is the directive principles of the state policy or the fundamental duties. Besides, the judiciary has also interpreted right to life to include a pollution free environment. So we find that the Indian Constitution recognizes the importance of environmental protection now and sustainable development. And it provides for the protection and improvement of the environment as a fundamental duty of every citizen. And the Constitution contains provisions related to the environmental protection under Article 21, right to life and liberty, and at the same time that right to life and personal liberty is interpreted by the judiciary in such a way so as to include the environmental protection also. Besides part 4 that speaks about the directive principles, and particularly we see Article 48A, and that mandates the state shall endeavor to protect and improve the environment, and it will also safeguard the forest, the wildlife of the country. Similarly, Part 4A, which is the fundamental duties that also confers upon every citizen the duty under Article 51AG, that every citizen has to protect and improve the natural environment. That includes the forest, the lakes, the rivers, and the wildlife. So, in addition to these, the constitutional provisions, India is also have enacted many environmental laws and regulations to protect the environment. And the most significant, you may be aware, is that the Environmental Protection Act of 1986, which provides for the protection and improvement of the environment, the prevention of environmental pollution, and the control of hazardous substances. And India has also established the institutions and agencies to monitor and to enforce the environmental laws and regulations. The Ministry of Environment, Forest and Climate Change is responsible for the formulation and implementation of the environmental policies and programs in India. There is the Central Pollution Control Board and the State Pollution Control Board. And they are also monitoring and enforcing the environmental standards and regulations. So, despite these efforts, environmental degradation and pollution remains a major challenge. Issues like air pollution, water pollution, deforestation, and loss of biodiversity continue to pose the significant threats to the human health and the environment. So, to address these challenges, India has committed to several international agreements also, and various initiatives have been taken that includes the Paris Agreement on the climate change, the United Nations Sustainable Development Goals, as I am talking about. So we can find that the environmental constitutionalism in India provides a legal framework for the protection and improvement of the environment. And we find that the Indian constitution recognizes the importance of environmental protection and sustainable development, and it also provides for the protection and improvement of the environment as a fundamental duty of every citizen, as a directive principle, which is an obligation on the state, and also as a fundamental human right, though through the judicial interpretation. So, for that, we have to look into the judicial approach for the environmental constitutionalism. And as I told you that we were not having any provision relating to the environmental protection in the original constitution. But the work and the role of the judiciary is very, very praiseworthy in respect to the protection of the environment, besides the constitutional and regulatory provisions. And environmental constitutionalism has been supported and enforced by the judiciary through a number of landmark judgments. The Indian judiciary played a vital role in interpreting and enforcing the constitutional provisions related to the environmental protection and sustainable development. One of the significant case in this regard is the case of MC Mehta versus Union of India. There are many cases which have been reported in the name of MC Mehta, and they have taken the many of the issues that is related to the protection of the environment, and where the Supreme Court of India took the suo motu cognizance of environmental degradation in the Taj trapezium zone, and also issued a series of directions to control the pollution and protect the environment. And this case has also led to the establishment of the concept of public trust doctrine in India, which holds that certain resources such as air, water, forest, and wildlife are held in the trust by the government for the benefit of the people, and that must be protected for the future generation. This is also the idea of the sustainable development also, that the things are not to be protected for the present generation, but it has to be protected for the future generation as well. So Indian judiciary has also been proactive in enforcing environmental laws and regulations. In a number of cases, the courts have directed the government as well as the private entities also to comply with the environmental regulations, and it have also imposed fines and penalties for non-compliances. And the courts have also ordered the closure of the industries and factories that violate environmental standards and also posing a threat to the environment and public health in the country. Who can forget the case of MC Mehta, which is known as the oleum gas leakage case, and that is also known as the absolute liability case, because that brought the concept of absolute liability against that of the strict liability. And this case explains the theory of public liability. It's a landmark judgment in which the principle of absolute liability was laid down by the Supreme Court of India. The courts were of the opinion that establishing any dangerous or hazardous industry very close to the human occupancy is hazardous, and for the hazardous for the public, and that the industries have to be relocated. That has to be located in an area where there is no human occupancy, there is no human residence, so that they may be avoided by the danger of any types of the pollution. So inclusion of the right to have a clean environment as a part of Article 21 is also one of the great work done by the Supreme Court in Subhash Kumar case, which has read that a pollution-free environment is a part of right to life and personal liberty, which is a fundamental right under Article 21 of the Constitution. Then again, if you see phasing out of the BS3 vehicles, and setting standards for the auto fuels for by invoking and interpreting Article 21 as a right to have pollution free environment. Again, there are directions by the Supreme Court which has banned the firecrackers in Delhi, the Ganga River pollution case, and the Indian Council for Enviro Legal Action case, where the court ordered the closure of factories and also pay them damages. Rural litigation entitlement Kendra case, where the court observed that preservation of ecology is a task which not only the states but also the citizens must undertake under Article 51 AG, because as I told you, that's a fundamental duty of the citizens. So they must also take part in achieving the pollution-free environment. And then we see that the Indian judiciary has recognized the importance of public participation in the environmental decision making. In the case of Vellore Citizen Welfare Forum versus Union of India, the Supreme Court held that the public participation is essential in environmental decision making. And it's the duty, government has a duty to inform and consult the public on the environmental issues that affect them. So the judiciary in India has played a very, very crucial role in enforcing the environmental constitutionalism by interpreting and enforcing the constitutional provisions related to the environmental protection, whether it is related to the air pollution, water pollution, vehicular pollution, at the same time noise pollution also, and by ensuring compliance with the environmental laws and regulations, the judiciary has done a very great. And it has also recognized the importance of the public participation, and it has taken the steps to ensure that the voices of the people are heard. The voices of the people in the environmental decision making process must be a part. However, there is a need for greater enforcement of the environmental laws and regulations, and increased public awareness is also very, very important for ensuring the sustainable development and environmental protection in. So finally, I can say that the environmental constitutionalism and sustainable development goals are closely linked with, as they both aim to promote the environmental sustainability and to protect the natural resources. So environmental constitutionalism provides the legal framework of environmental protection, while sustainable development goals provide for the goals and targets for sustainable development. And therefore, by adopting and implementing these frameworks, countries can work towards achieving the sustainable development and ensuring a clean and healthy environment for all of